Barber.
Okay, well, I think we can get going here as we've got attendees filtering in. I know it's going to be a pretty interesting conversation here today. I'll go ahead and pull the presentation up so that everybody can see what we've got going. We're here today to talk about patents for product development staff. I want to thank Bob and the select committee and Nicole from ETTN for inviting me to participate here today. For those who don't know me, my name is Jeffrey Banyas. I am a shareholder in the law firm Sisson and Banyas Attorneys at Law out of Northeast Ohio. Grew up in the automotive industry. My family growing up and still to this day owns a race engine shop outside of Cleveland, Ohio, called Victory Engines, where I spent a lot of my youth disassembling and machining on engines. I was a race car driver in a past life, driving quarter midgets, sprint cars, super modifieds. Since 2010, I've been a practicing attorney. I am a licensed patent attorney. And given my background and my passion for all things automotive and high performance, the firm in 2016 started getting involved in it with SEMA, done a lot of volunteer work for SEMA, and a large portion of our business is in representing companies in the automotive aftermarket. I have with me here today Matt Beenen. Matt is a mechanical engineer by trade, spent a number of years as a product development lead for Grimspeed, and most recently struck out on his own and founded and is president of Built Right Industries and Mountech, designing and manufacturing and selling cargo storage solutions. And Matt Beenen is a inventor himself on 4 granted U.S. patents. We also have with us today Matt Patrick. So we've got Matt and Matt squared. Matt has a degree in automotive engineering technology. He is currently the technical director at DeatschWerks, where he heads up product development. Prior to that, he was the director of product development at Comp Performance and later Edelbrock, where he's led up teams in product development and product launches. And Matt Patrick is an inventor on 6 granted U.S. patents, at least that I'm aware of. So Matt and Matt are here to provide kind of the experience from those who are in the attendees' shoes, not only as inventors, but people who have led product development efforts and gone through the patent process themselves. And I'll be tossing it over to them from time to time for their thoughts and their insights. Really what we're trying to do today is give you guys some best practices, and we will save some group discussion for the end, getting into any questions or comments that you have. Feel free to go ahead and put those into the chat, and Nicole will be monitoring that, and we'll get any of the chat questions over to us at the end. We'll do the best we can to answer them. The objectives really for today, we want to give you guys a practical background on patents. You're not going to hear a lot of 35 USC section 103 says da 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 da. Well, that has a lot of legal meaning for people like me who are practicing law day in and day out. From a practical standpoint for you as a product development person, as somebody in engineering, as an inventor, doesn't have very much practical meaning. What we really want you to come away with today is the ability to read and understand patents and patent applications as a research tool. Some best practices on how to identify potentially patentable ideas and when and how to act when those patentable ideas arise. and to understand when and how to act when you come across a competitor's patent, which can be every bit as important. And I know Matt P. Has some interesting stories about some of those issues that have come up in his past experience. So digging down into it, what is a patent? I often get the mistaken belief from people that a patent has to be for something that's really groundbreaking, right? You know, we're thinking about Edison and the light bulb. We're thinking about Bell and the telephone, Benz and the automobile. And what I always tell people is the United States Patent and Trademark Office, in its nominally 250-year history, they've granted over 11 million patents. Not all of those have been for groundbreaking inventions. Most of those are for incremental improvements on existing technologies, but often those incremental improvements can have value to you as the inventor or as the company employing the inventor. So I can give you the clinical definition of a patent. It's the exclusive right to practice an invention granted by the government for a limited time. Typically, that's 20 years from the date of filing, in exchange for a full disclosure of how to practice the invention. So the deal is you tell the patent office how to make and use and everything about your invention. In exchange, you get that 20-year, let's call it a monopoly, the exclusive right to use. From a practical standpoint, from a clinical standpoint, that's what a patent is. From a practical standpoint, for most of my customers, we look at these in terms of business assets. A patent is a business asset, just as any other piece of intellectual property, a trademark, a copyright, a trade dress, trade secret, whatever it may be. They are business assets, and they should be treated as business assets. You can use them to deter your competitors from entering the market in that particular product. You can use it for licensing purposes. You can use it to raise capital. Yes, there are people, there are banks that will loan you money or provide financing in exchange for equity, based on the strength of your patents and your patent portfolio. You can use them to negotiate pricing with retailers and distributors. They are not just used to enforce against an infringer. All of these are things that are really designed to protect your market share in your products. And so at this point, I would like to turn things over to Matt B. You'll see here several of the patents that Matt Beenen has been granted, along with the corresponding commercial products, and just get a little bit of your insights, Matt, as to how you approach and how you think about patents relative to your business.
Yeah, thank you, Jeffrey. I appreciate the opportunity to join you guys. Happy to share here. I'm also excited to learn. I have to say, I flipped through this deck really quickly, and I'm excited to hear it from Jeffrey because although I do have a few patents to my name, I really rely on Jeffrey to tell me what is good, what isn't good, what needs to happen. So ton of credit there. But the way I look at patents, so that center patent right there for the rear seat release is something I invented in my basement with an old Singer sewing machine back in 2016, 2017. And I'm so thankful every day that I pursued that provisional patent application and ultimately connected with Jeffrey to get the non-provisional granted. I came from part of the market, and all I ever heard from people was like, not worth it to patent it, or once you have the patent, then you have to pay hundreds of thousands of dollars to enforce it. And I'm sure that is the case in some cases, many cases, but in other cases, it's not, for all the same reasons Jeffrey just mentioned. So this is a patent that pays for itself like every few weeks. And so that was like a good lesson for me to learn early. And it's resulted in a number of other patent applications and granted patents on products when we feel we've got something truly unique from a utility standpoint. And so that's on the left there is the bedside rack system. So if you've seen Molly panels in the bed of a truck, we were the first to do that. We've got that utility patent. That is a patent that is a little bit more complex to enforce. And so kind of approaching that more strategically with a long-term plan. And then on the right there is our seat back Molly panel. This is the first of what I know will be many patents where we just, as a standard practice, as a part of our product development process, we're going to pursue utility patents on things that we know are unique as a way to protect our engineering investment, our product development, our marketing, all that money that we put behind a product to get it out into the marketplace. It's kind of insurance against somebody else coming and riding coattails. So just really, I've been fortunate to learn this lesson, I think, the easy way, kind of. That center patent took about 4 years to get granted. And it was pretty painful because in that amount of time, we had 60 plus sellers, manufacturers knocking off that product. And with that patent being granted, we're able to keep a pretty good lid on those. So, yeah, I would say the only other thing to note is just, again, I mentioned up front, but Jeffrey's really my resource for this. And I know he's not here to pitch himself, and I shouldn't be, but it's just as an engineer, as a product developer, I'm not an expert in patent law, and I don't want to be. So it's really nice to have somebody who I can pick up the phone, understands the industry, understands the product and the business, and can provide guidance. So I don't know if I answered any questions there. I hope that's kind of just my brain dump.
Well, thank you, Matt. I think that's a really great way to hear from somebody in the inventor business owner shoes on how you think about patents for your business. And it dovetails nicely. We were talking about, you mentioned things being unique or having utility. Next thing I was going to get to here is what makes an idea patentable. Again, I'll bring up most of the inventions that are out there are not for Edison's light bulb or Bell's telephone. And so you need to have an understanding going into the patent process of what is it that makes something patentable. There's generally 3 requirements that I have posted here. The first one is it has to be new. You'll hear this referred to as the novelty requirement. And basically all that's saying is, has somebody done exactly what you're doing? Is there one document? Is there one publication? Is there one prior patent? One product that was released at a trade show that is exactly what your invention is? If that is the case, you are probably not patentable. But if nobody's done exactly what you're doing, you've probably met that requirement for novelty. The second requirement is where we tend to have most of the debate at the patent office with the examiners, and that's the obviousness requirement. You'll also hear it referred to as having an inventive step. And that is really looking at, can one disclosure that happened previously that wasn't exactly what you've invented, can you take that close prior art, modify it, and come up with what you've invented? And there's a lot of debate that goes back and forth between myself and inventors and examiners over obviousness, and I'll get to some of the standards as to how obviousness is determined. But that is going to be your second requirement. And then your third requirement is usually your lowest threshold. Is it useful? Does it have some utility? Generally, if your invention can do anything more than serve as a paperweight, you're probably going to meet the utility requirement. And as I sit here today, I can't think of an invention, certainly in the automotive space, and we've done a lot of them, that has ever had an issue with the utility requirement. So it's not one we'll spend a whole lot of time on. When we're thinking about obviousness, this is one of the first places that I would get your pencil out, take some notes. Obviousness is judged against a hypothetical person of ordinary skill in the art. That's the phrase you will hear thrown around by the patent office and the courts all the time, the person of ordinary skill in the art. And for most industries, most technologies, you're talking about somebody who has an associate's degree or a bachelor's degree and maybe around 3 years of experience in the field. You are not talking about an expert in the field. People like Matt and Matt are people that I would consider to be experts in the field. They have years of experience. Sometimes you might have somebody who has a master's degree or a PhD. Oftentimes, that is the most dangerous person in your product development team or in a research organization because everything is obvious to them. And we have plenty of debates with senior researchers and senior product development folks about, no, the standard isn't judged against you with 25, 30 years of experience, master's degree, whatever it may be. It's judged against the person of ordinary skill in the art. So what I would caution you is if you are that person who is an expert in the field, highly experienced, highly trained, put yourself in the shoes of someone who is only 3 years into the job. Would the solution, would the invention, would the product that they came up with, would it be obvious to somebody at that level of their career? Not to somebody who has 25, 30 years of experience in the field. You don't want to be the person who walks past a potentially patentable idea and loses patent rights because it was obvious to you when it, you aren't the one that obviousness is judged against. So what are some leading indicators that you might have a patent on the horizon? These are just some things that we've experienced over the years that have been early indicators of a potentially patentable idea. Number one is you solve the problem. In Europe, you'll hear them refer to the problem solution approach. Was there some problem with the prior art, the previous inventions that were out there in your field? Did you solve the problem? And if you solve the problem in a way that's non-obvious, you probably have something that may be patentable. Second one, a senior researcher has never seen that before. Remember, I talked about that heavily experienced expert in the field. If you've tripped that person up, shown them something that they've never seen before, good chance that you probably have something that's patentable and non-obvious. Number three, you got 2 or more people in your organization that disagree about the cause of an observed phenomenon. Think about if you're developing, say, a new cylinder head, and you've spent months and months developing this, finally got it to dyno testing, you've got a 10% increase in horsepower off the dyno. And one person involved says, it's got to be attributable to X. Maybe X is you change the intake valve angle. And another person says, no, it's got to be attributed to Y. That's got to, Y has got to be the reason why we got all this extra horsepower. Maybe Y is, we changed the dimensions of the exhaust ports. I don't know. If you've got 2 researchers that can't agree on why you got such a good result, probably something that you need to be reaching out to your patent attorney, that you may have a patentable idea on the horizon there. Along the same lines, if you start having excitement build within the organization, people are talking in the lunchroom. Did you hear about what Matt and Matt achieved with their latest test, their latest experiment? That's a pretty good indicator that there's something surprising out there, something that wouldn't have been obvious to that person of ordinary skill in the art, and that might be patentable. Or if you got some type of unexpected result, if you were expecting a 5% improvement in horsepower on the dyno and you got 10. Now, that's unexpected results are a good way to get around an obviousness rejection. If it was unexpected, how can it be obvious, right? So you got an invention that could potentially be patentable. What do you do next? Matt Beenen sort of alluded to this earlier. Bring it to the attention of management and call your patent attorney. It may end up being a situation where management or your organization ultimately decides not to file a patent application, Maybe a situation where your patent attorney goes back and does a prior art search and finds that there's some prior art out there that renders it not novel, or there's an obviousness issue that we're just not going to be able to get around, or there's just not a large enough commercial market to justify the investment in trying to patent it. But you want those to be affirmative decisions. Those should never be default decisions that are made in a vacuum. You want to have the information at hand. You want to bring those to the attention of your patent attorney and of your management team so that you can make an informed decision about that, as opposed to defaulting to, nope, we're not going to file a patent application on that. And then 3, 4, 5 years down the road, you wish you had. The things that you should not be doing, don't be sharing it with anybody outside of your organization. When we talk about that novelty requirement, one of the things that can break novelty is if there is a publication outside of the organization, and that can be as anything as small as a social media post. As soon as that post goes out there with details of your invention, the clock is ticking. And in the United States, under certain circumstances, you will have 1 year or 1 year grace period to file your patent application. Not every country is as forgiving as the United States. Europe, for example, has no grace period. As soon as that publication goes out, you're no longer novel, no patent for you. So you don't want to be publishing anything in research journals and social media, blogs, message boards about your idea until you've evaluated it for patentability. And if you are going to file a patent application, make sure you've got that filed before you publish. The other reason you don't want to share your idea outside of your organization is that in the United States and around the world now, we are a first to file system. So even if you can prove that you invented something before a competitor or another party, if they beat you to the patent office and they file their patent application first, the law says that they are entitled to the patent, and you don't want any of your ideas getting into unscrupulous hands and having somebody file a patent application and beat you to the patent office. And so this is where I'm going to turn things over to Matt B and Matt P for just a little bit of insights into how the two of you have handled potentially patentable ideas in your organization and what steps you've taken when these types of situations come up.
Matt P, I'll let you kick it off.
All right, sounds good. All right. Forgive me, how do I move to the next slide?
Which slide are you looking to go to?
Oh, just, I thought that was, yeah, teed up in the deck, I think.
Yeah, we'll have this one that was teed up a little later on here.
Okay.
Okay.
That's
one you're looking for?
Yeah, I'd be happy to. Okay. Well, I wanted to share with the attendees kind of a real world example of something that came up that really had a nice blend between technology and business practicalities. This was a valve spring compression tool that was actually developed. The previous design that there was some issues with was part of a company that was acquired. So company was acquired, their product line was rolled in, and we quickly received a cease and desist letter from the owner of the patent of this product on the left-hand side. And there was some negotiations that went on trying to find an amicable solution. And in the end, we couldn't come to an agreeable or, agreement. So really it came down to, we had to stop selling that particular product. So there was thousands of sales and quite a bit of revenue attached to this tool sale. So basically I was challenged with coming up with a way to effectively not get basically just look at the claims and just get around the patent essentially, and not basically be in violation of the patent owner's patent. So it was really kind of a fun exercise because I sat down with our engineering team. And if you want to get engineers fired up, give them an example of something where they got to go out there and beat somebody else. We've talked about, obviously, many of us are in the racing community, and the idea of competing against other companies and beating them in the sphere of product development is kind of a fun deal. So we sat down and went word for word through all the claims in the patent. And realized there was a little bit of a hole, and in particular, the portion on the left-hand side, you'll see the competitor's patent referred to that conveyance up and down on that threaded shaft. That was the key claim that was really, we were having a tough time getting around. And so the product on the right-hand side is what our engineers came up with to sort of get around the specifics of that claim. And instead of conveying up and down on that threaded shaft, we really had a separate device that was using a thread that pressed on the actual device, so it wasn't conveying up and down over the threaded shaft. And so I think the important point to note on this is that the words really matter. The claims are where the magic happens, and really that's what matters, is that what is the actual person that holds the patent, what are they claiming? And so by essentially picking it apart, realizing there's some ways we can get around that, we were able to design a product that did not infringe on the claims of their patent, and we're able to then develop it and go back to market and effectively regain all those sales and grow it a substantial amount. So the beauty of it is that we stopped infringing on someone's legitimate patent. We had a very sellable, good product that had some of its own merits that came from it. And the business benefited, and the engineering team really got a good exercise in understanding how to get around certain claims of other patented products. But I'd say in the big picture, it also taught us a great lesson about, in general, when you approach any given product development project, a part of a good process is to always do a certain level of patent search. So if you're going to design a product, just simply do some keyword searches within the a patent search. Google Patents is a really good one that we've been using. But do a general topic search on that area and do the research. You'll find a lot of ways of doing something you probably are thinking of. And it gives you the opportunity to find patents that may be already having claims in areas that you were going to develop a product in, and gives your engineering team an opportunity to kind of work around that and essentially not infringe on people's patents. So I think it's a healthy exercise, and this real world example that I'm showing you really helped us as a team get smarter about how we develop products, especially in highly competitive environments. This one happened to be for a tool, but in the engine development we did with a lot of valve train components, cylinder heads, intake manifolds. Some of these are highly competitive areas, and very key claims for different types of patents can mean the difference between having a successful product technically or not. And so it's a good exercise and a good skill set to develop within an engineering team.
Matt B, anything to add to
that? Yeah, I mean, I guess when we come across the potentially patentable, or how we kind of approach that, I think from a small business perspective, again, when I got my first patent, I was doing this out of my basement. There's not to be underestimated is the cost and the time required, the complexity of getting a patent. And so Jeffrey gave a lot of best practices there. For me, I would have loved to have kept that idea in my back pocket and applied for the patent. I probably would have gotten it more quickly, frankly. But at the same time, I needed to sell the product, and in order to A, afford to apply for the patent, and B, to understand if it was worthwhile commercially. And so that example is on the opposite end of the spectrum, which is it would have been good to keep that in my back pocket and probably saved some time and headache and expense. But at the same time, I was able to afford it and feel comfortable going through the process. Now I've gotten a lot better about doing what Jeffrey suggested, which is to call him and get in touch on the early side, and to be more patient now that I can afford to apply for a patent prior to selling the product. So just, I guess, a comment regarding the the financial piece of this for a small business owner. And I would encourage a person to still consider applying for a provisional application or a non-provisional patent, even if it seems really expensive, because again, it can pay huge dividends down the road.
Matt, that's a great point you bring up, and I wanted to add to it. In the same way as when I've looked at, should I patent something or should I not, is what is the revenue potential of the idea? If that key technology that I want to patent is part of something that, has forecasted of, millions of dollars of revenue, 100%, it's at that point, you're talking about profits that can support the defense of a patent if someone tries to infringe on it. And in part of an overall product development process, you can essentially work that into a workout for a budget for developing a new product. And so I think that's a very important part of it. And likewise, conversely, looking at the value of, well, if I can't, if I've got a small novel little idea and there might only be a few $1,000s of revenue attached to it, and it seems like maybe it's a secondary product, value can be defined in a lot of different ways. And oftentimes, if it's a novel idea, and let's say it doesn't quite meet maybe call it the commercial threshold, there are real reasons from a market standpoint why you might want to attach a patent, let's say, to add that perception of it's a really advanced technology that can help support a product line. So even if it doesn't really pass that threshold of like, hey, I really need to defend a huge revenue stream, consumers look at a patent as like, wow, that company really knows what they're doing. They're smart, they're innovative. And so sometimes there's a different value associated with doing patent pending or, pushing it all the way through to a full patent, because there is real value being generated, even if it's not just a pure, dollars and cents side of the equation.
Yeah, and actually, if I can just riff on you made me think of something too. One of the things that I've kind of learned to do is once we have that patentable or potentially patentable idea, I immediately start thinking of other possible ways that I could achieve the same result or the same utility in order to come up with and imagine these different embodiments where a person could, like you, Matt, could potentially design around my valve spring compressor and try to anticipate that. Because what I've learned is that the better that I can anticipate that, the better Jeffrey and his team or whoever you're working with are able to help you work those claims out. The other thing is it also typically ends up improving the product because it forces us through that exercise of considering all of the possible ways we could go about doing something. So it's really like there's a benefit on both ends there for us. That's
a great point. And Jeffrey, it's funny, Matt, you said something that got me thinking too. Talking about how broad the language used, I know when I first, started to do my first patents and learn about the process, I was thinking about, boy, I want to get every single detail that I can possibly get into this thing and really nail it down. And it literally is the exact opposite. You want as broad a language to capture as much potential, variations on those themes as you can. So kind of, Matt, to your point, yeah, it's almost like I want to broaden out the scope of the language as best I can. And that's where someone like Jeffrey comes into play and really helps to kind of guide that process and keep it as broad to essentially get the maximum amount of protection within the language that's used in the claim section.
Well, thank you both for your insights on that. I think there's a lot of really great points that you've brought up in terms of claim scope and designing around competitors' patents and thinking about it, again, in terms of business assets and what is the market that you're trying to protect, and the marketing component that comes along with patents as well. Moving on into some more of what I would call the looking at your competitors' patent side of the presentation. First off, research standards for patents, and this gets into a little bit of what Matt were talking about. If you are getting to the point where you're researching, you've got your engine on the dyno with your new cylinder heads on it, and you're trying to support patentability with some type of unexpected result or some type of improvement that would make you non-obvious, you really want to be conducting those experiments in line with good scientific research methodology, changing one variable at a time. If you're changing multiple variables and you're trying to then go back to the patent office and say, I have an unexpected result that's based off of this one variable, expect to hear from the patent office, well, how do you know it's that one variable? How do you know it's not the other variable? Even if you think the second variable is insignificant, everybody knows that the two have to be changed together. The patent office is going to come back and take a look at that and say, no, we can't tell. So that's just a practical tip for your research organization, for your product development organization when you're looking at experiments for supporting patentability. Those experiments may not be necessary for go to market, but they are kind of necessary for patentability purposes. When we start looking at competitors' patents, one of the first things that I can't tell you how many times I've been through this is what is the difference between a patent application and a granted patent? I will probably 4 or 5 times a year, I will have somebody come to me and say, I can't go forward with this particular product that I'm developing because my competitor has a patent on it. And when we look into it, it's really a patent application. Maybe it has some really narrow claim scope like Matt P was talking about. Maybe there are ways to design around it. Maybe it doesn't even apply at all to what you've invented. So you want to be looking at patent applications will get published 18 months after they're first filed, and that can create some confusion. You don't want to really be looking at a patent application the same way you would be a granted patent. A patent application is a great research tool. It can give you a lot of information about what your competitors are doing, what the state of the art is out there in your field, but it's not a granted patent that can be enforced against you. So how do you tell the difference? Well, same invention, same application. On the left-hand side, you have the published application. On the right-hand side, you have the granted patent. And the first thing that you'll see is in the application, it's going to list United States Patent Application Publication. You're going to see it's going to have a publication number that's going to start with US, followed by a year. This one was published in 2011, and it's going to end in A1 or A2. On the flip side, you have the granted patent. It has United States patent, nothing about an application publication. It's got a 7 or 8 digit granted patent number that ends in B2. That's a granted patent. That's one that could be enforced against you or another party manufacturing or selling a similar product. The other one that I love hearing all the time, I have an international patent. No, you don't. Anybody who tells you they have an international patent, they're full of caca. There is no such thing as an international patent. There are international patent applications. They fall under an international treaty called the Patent Cooperation Treaty. You'll hear them referred to as PCT applications. They're administered by the World Intellectual Property Organization. And the way to identify them, you will see them published up here in the upper right-hand corner with a WO publication number that ends in A1 or A2. That is an international patent application. It is not a granted patent internationally or in any individual country, and it's not going to necessarily be enforced internationally or in any individual country. You can take your international patent application and extend it into individual countries, the US, Canada, Australia, China, European Patent Office. Most industrialized countries are a member of that Patent Cooperation Treaty, but you still have to go through the examination process and the grant process when you get to those individual countries before they will grant you your quote unquote B publication that you can then go ahead and enforce. When you're looking for patents, there's a lot of great free resources out there for patent searching. I've listed a few of my favorites. The USPTO has a very good system available for searching US patents. It's not going to give you any patents outside of the US, but anything that's available that's been filed and granted in the US, you'll be able to get there. My favorite is Free Patents Online. It's a very robust platform. It's up to date. The only downside to it is it's got some weird interface issues. It's very Boolean based searching. So you got to be somewhat familiar with that. Google Patents, I know Matt P mentioned that he does some searching on Google Patents. It is a good resource. So you will get a lot of your patents, not just from the US, but from Europe, from China, from other countries. I've just not found it to be as up to date sometimes as Free Patents Online or the USPTO website, which is why I shy away from it at times, but it is a very good resource. And it's a little bit more intuitive. It's very much like running a Google search that we're all familiar with for, what restaurant you want to go to that night. What do you want to search for? Keywords related to your industry, your products, or your R&D efforts, or look for the assignee name of your competitors. If your competitor is XYZ Corporation, run an assignee search for XYZ Corporation. See what patents they have. What are they doing with their technology? What applications do they have filed? And then once you've found a competitor's patent or a patent in your industry, how do you read it? And Matt P alluded to some of this as well. You really want to read the patent as a whole, not just for what it teaches you about the science or the engineering, but what it teaches you about the novelty or non-obviousness of other people's patents. A lot of times when we get into an enforcement action, what we will be looking at is the patent valid in the first place? Should it have been granted in the first place? Was there prior art out there that the examiners at the patent office missed that could have rendered it not novel or could have rendered it obvious? So be thinking about those types of things. Is this going to be a valid patent? Have I seen anything like this before? Have I seen something exactly like this before? A majority of the patent is going to teach how to make and use the invention. Remember, that's the trade-off between the patent office. They give you the grant, they give you the 20-year monopoly. You teach them how to make and use the invention. So when your 20-year monopoly ends, it goes back into the public domain and can be improved on. Those portions don't really impact the scope of the patent for protection purposes and for enforcement purposes. They're there for interpretation purposes and to meet that burden of teaching how to make and use the invention. The claims, which are typically at the end of the patent, are what define the scope of your protection. They're often in very archaic language, which I hate having to write, but it's what we have to do. They can be limited by statements that the patent owner made to the patent office in that back and forth with the examiner. So you never want to necessarily assume that the plain language of the claims is going to be governing in all situations. And that's really why you want to always reach out to your attorney before commenting or making assumptions about what the scope of protection is on a patent. The four main parts of a patent. We've seen a lot of the cover pages that has no real bearing on the patent scope. The drawings are what people tend to get focused on, maybe a little bit too much, because they're easy to look at. Picture's worth 1,000 words, right? Again, the drawings are really there for interpretation purposes and for understanding purposes. They don't really have much impact on the scope. Then you'll get to your specification, which is a long written description of the invention and how to make it, how to use it. And then the very, very end of your application will be the claims. They'll start with some form of I claim or we claim or what is claimed is. They will be numbered 1, 2, 3, 4, 5, and so on. And that's really what you're looking at for enforcement purposes. That's what you really need to be focused on if you're trying to figure out, if I go forward with this new product that I'm developing, am I going to be infringing somebody's patent? Don't be focusing so much on the drawings, focus on those claims. Matt P already got to this a little bit, but never ever assume that you cannot pursue an R&D opportunity just because you found a competitor's patent or a published application. Again, going back to one of our first slides, patents can be licensed, they can be sold, the validity of them can be challenged, or as Matt P so aptly demonstrated, they can be designed around. So when you come across a competitor's patent, even if it looks like they've got you dead to rights, even if it looks like they're right on top of what you're doing, don't necessarily assume that that should stop you from pursuing a product development or an R&D opportunity, because there's always ways to, well, I won't say always, but there's usually ways that you can go about addressing a competitor's patent.
Yeah, and I think I'd also want to second Matt's comments about, oftentimes that process actually ends up improving the product. And I think that was a great point to bring up. I've seen the same thing happen, that you think, oh gosh, we can't go after this product. Someone's already got a patent, and then you get your bright, creative, product development minds all put together in one room, and next thing you know, you're actually coming up with a better product. And I think that's a really neat part of the creative process, is that these are not roadblocks. They're oftentimes just creative opportunities to find a way to do something better.
Yeah, thank you, Matt. So what should you do when you come across a competitor's patent or patent application that you think is important to your business? This is going to sound a little redundant. Bring it to the attention of your management team, call your patent attorney, do it offline and in person. And there's very important reasons for that, because what you don't want to do is start putting things in writing, putting them in emails, commenting to your management team, making notes in the margins of the patent. If you find yourself in a situation later on down the road where you're involved in litigation, and I've been involved in some of these, the last thing that you want to be doing is sitting in a deposition with opposing counsel for the patent owner across from you, asking you questions like, Mr. Smith, why did you tell your president or your vice president of product development in this email dated February 18th, 2025, that if you manufacture this product, you'll be infringing XYZ company's patent? What did you mean by that? If you've not had an analysis done by a patent attorney and claim charts completed and interpretation and claim construction, that is not the time to be commenting, particularly in writing, about whether or not you're going to be infringing a competitor's patent. And those documents will come to light in discovery, and those are tough conversations to be having, and put you and your management team and your company and your patent attorney, selfishly, in a very bad position that you don't want to be defending against. So always bring those issues to light offline, and bring them to the attention of your patent attorney. Getting to the end here, I think if there's 4 or 5 really important takeaways for today. Number one, you don't have to be an expert with a PhD or decades of experience in order to be an inventor. Again, remember, we're judging patentability against that person of ordinary skill in the art. The patent of you should never assume that you cannot pursue an R&D opportunity just because you found the competitor's patent. If you do have an invention, or if you found the competitor's patent, that you think might be relevant to your business, go ahead, bring it to the attention of your management team, and bring it to the attention of your patent attorney so that you can make informed decisions as opposed to default decisions on whether or not you're going to go forward with things. And I see Nicole has posted in the chat. If anybody has any questions, we definitely appreciate your attendance and your participation. I think we've got about 10 minutes left over here. So we'll give you a few minutes to type your questions out and we'll do the best we can to answer them. Matt, anything to add here before we sign off?
Like I mentioned right up front, I definitely learned a thing or two. Appreciate all the information. I think one of the things that you mentioned, you wove it in here a couple of times, and I'm working on building this habit, but I also understand why it exists. A lot of times it is a knee-jerk reaction to send an email or a text message or whatever it is. All of the attorneys that I know really like to pick up the phone and have a phone call as opposed to documenting the conversation another way. So I think that was a good tidbit.
Yeah, I had a thought to add. I would call it maybe the tactical use of the patent pending. There are times, if you look at the overall cost structure for applying for a patent versus like completing it to its end, it's quite a bit less to do, just apply the paperwork and be allowed to say patent pending. And I've used this at times throughout the years to where if you think about it, I think, and Jeffrey, correct me here, you've got about 2 years for the application process, right? Give or take.
Yeah, it's going to depend. Once you've filed your provisional application, you have 1 year to convert it to a non-provisional application. And once you're in the non-provisional phase, that's when you will get examined by the patent office. And that process from there can take anywhere from 6 months all the way up to, we've had some that have taken 4 or 5 years.
Oh, wow.
So 2 to 3 years from first filing to grant is kind of an average, a good average.
Okay. Well, I think what I have learned is, oftentimes consumers aren't nuanced enough to know the difference between patent pending and a granted patent. So if you are looking at, let's say, a novel technology, and really anything can be patent applied or patent pending, right? You can apply for a patent on it. I have used that at times to essentially kind of elevate an exciting new product and technology and simply put it out there as patent pending. You get I would say, the marketing buzz of like, oh, wow, this is a really novel idea. It's got patent, that word's associated with the product as you go out there and your marketing efforts. And then really down the road, let's say you're down the road a year or two into the patent application process. Let's say the product hasn't been commercially successful. It didn't really take off like you were hoping. You can abandon it at that point. Essentially, eliminate, cut your losses, so to speak, and move on to some other project. Whereas let's say it has been fabulously successful, there's a huge revenue stream coming in that you realized, then you look at it and go, hey, absolutely, this is a great investment. Let's continue down that road. So I've liked to see where I've used this in my career in multiple ways of, I'm very liberal with patent pending and patent applications. And I'm typically a little bit more careful about what I push all the way through to receiving a full patent granted. That process takes quite a bit more time and effort, but I just want to throw that out there as a bit of a nuance that even if you don't think you have the ability to go all the way through the end, sometimes just applying for the patent, having that patent pending, able to be used as you market a new product can be very beneficial as well.
Yeah, and Jason has commented on that in the chat as well. And thank you, Jason. Thank you, Matt. And Jason's absolutely correct. There are rules that exist about when you can say something is patent pending and when you're not allowed to say it's patent pending. A lot of people will start using patent pending as soon as their patent attorney starts drafting the application. Well, you're not technically patent pending at that point. You're not patent pending until you've actually gotten an application on file with with the patent office. And you're only pending until the patent is either granted or it has gone abandoned. Like Matt has said, you know, sometimes you may not choose to go all the way through for commercial reasons or one reason or another. You may not go all the way through to a granted patent. If you do decide to allow an application to go lapsed, you got to stop using patent pending, and there are consequences. You can have some liability for false marking if you're marking a patent as an application or a product as patent pending when you don't actually have an application granted. You can have liability for marking a product as patented when the patent has expired or when you haven't paid your maintenance fees on the patent. I've got a real interesting story from a few years ago. We had a customer of ours here locally who asked us, he said, you know, we're getting calls all the time to develop this particular product. It's a kind of a commodity product, but the industry, nobody wants to manufacture it because everybody knows that there's this one company, one competitor of ours that has a patent on this. Can you look into this for us, and what can we do? What are your suggestions? So we started running it to ground, and we got our hands on some of the engineering drawings for that particular product. And sure enough, the engineering drawing had the patent number written right there. It's a pretty old patent. So we go back and start looking at it in the at the USPTO and come to find out that it had expired like 5 years earlier. And yet the entire industry was still saying, hands off that product, hands off that product. That company has a patent on it. And they were apparently still marking their products and their engineering drawings with that patent number. So yes, some significant liability potentially attaches there. You don't want to be that person that that has to go back to your president or your CFO and says, well, we got a lawsuit on our hands now because we got false patent marking. So very good point, Jason, and very good point, Matt. You know, when you start treating these things as business assets, sometimes you will have to let an application go. And sometimes you will be filing an application knowing that the product life cycle for that product is maybe only 2 or 3 years, and then the next generation is going to come around and render it obsolete, but you want to have patent pending on it for marketing purposes for those 2 or 3 years, that it is, you know, a viable product. I think if there's one big takeaway that I would come away from this seminar with, think of these in terms of business assets and how you're going to use them to protect your market share and improve your cash position. I don't see any other questions. I'll give it another second or two if anybody else has anything they want to ask to myself or Matt. But I do.
Did you answer the one from Jeremy in here? I'm so sorry. I can't remember right now.
I'm not seeing it. Can you read it off?
Yep, I can definitely do that. For products that are not utilitarian or may fit the criteria of a paperweight, as you put it, thinking automotive accessories such as emblems, what protection is possible if not a patent? I'm thinking copyright, trademark. How do those differ in their application process and in their protection?
Yeah, so we've spent a lot of time talking about what I would call a utility patent. There is a separate type of patent called a design patent that will cover the aesthetic appearance of a product. A lot of times you will see this used for vehicle wheels, headlights, taillights. A lot of the things that you'll see at the SEMA show would be subject to a design patent. There's not necessarily a utilitarian advantage to one particular design of wheel versus another, but there's an aesthetic component that goes into it. You can apply for a design patent. It has the same requirements as a utility patent in terms of it having to be a new aesthetic design, a non-obvious aesthetic design. It does not have that necessarily have that requirement for usefulness because again, we're thinking about only the aesthetic appearance of the product. Those are really good assets to have for guarding against knockoff products, because it's very easy to sort of compare side by side. Here's the aesthetic appearance of my product and my design patent. Here's the product I'm alleging infringes. Do they look substantially similar to an ordinary observer? If the answer is yes, you probably got an infringement, and you're not necessarily going to have to go through as much rigmarole on claim interpretation and things like that. So that's really one of the first assets that you'll be looking at for non-utilitarian components. And then when you start getting into things like trade dress or trademarks or even copyrights, those are things that you can look at a little bit different outside of the scope of a patent. You know, a trade dress is going to protect the aesthetic appearance of a product packaging more than necessarily a product. It's very hard to get a trade dress registration on a product itself. Trademarks usually going to be going after things like brand names and logos. Copyrights will be going after artistic works, which can include everything from, you know, paintings and photographs to engineering drawings, marketing literature, things like that. So hopefully that answered your question, Jeremy. I'm sorry I didn't see it in the chat. Nicole, if there's any more that I've missed over here, please let me know.
No, sir, that is all.
All right, well, we're about 1 minute over, and definitely appreciate Matt and Nicole and the whole SEMA ETTN crew for inviting us on here. I hope you guys found it useful, and hopefully we'll see you all at the next SEMA event, if not at the SEMA show.
Sounds great. Thanks for having me.
Thank you, everyone.
Thanks, everybody.